Hey everybody, good morning. My name is JD Houvener, and I'm your host today of the Bold Today Show. You've made it to the Bold Patents show, where I'm going to be presenting, answering questions and answers from a live audience here, as I am every Friday morning, 9 a.m. Pacific and noon on the East Coast. So today is 9/11, right? For a lot of those that lived through, the atrocity of 9/11, it's definitely just that date. It just reminds you of that time. So just wanted to make sure everyone else is thinking about how grateful we are, to be where we are, to have what we do, and to cherish, every day, right? We're not under attack. If we're living life, free people, be thankful for all the military and those that serve to keep us protected. A kind of less serious subject. I want to, of course, encourage our entrepreneurs, innovators, and business owners here to know that they're making all of our lives better, and that's really what gives me an incredible surge of energy whenever I kind of get down or wonder about what I'm up to in my career. I'm helping inventors change the world for better, and it's just encouraging that everyone I talk to, all of our prospective clients and actual clients that are making a big difference in the world, that is the lifeblood of this country and the world, for that matter, and how we're going to continue to do better and improve all the time. Especially relevant in this world of COVID and this world of, can be isolating and, new world, and things are changing so quickly. What hasn't changed is the human spirit and the motivations and the efforts that we're all making to do better out there. So kudos to you. Thank you for your efforts. And that's kind of big reasons why I'm here. Is to help, every Friday, help answer any questions you've got about the patent system, patent laws, anything that you might be stuck on, wondering about, and want to give you a link. I presented this, every week. I want to make sure you get a copy of my book. It's the number one best way to get started if you're just starting your journey. And I've got a copy behind me. I wrote this book just a few years back, and it's got all the relevant subjects. Whether it's innovations, moving from idea to invention, patent searching, provisionals versus non-provisionals, office actions, how long does it take, how much does it cost? It's all in this book, and it's via free PDF download on our website today. So if you're out there wondering how to get started, that's the best way to do it. Disclaimer here, of course, as I do mention this every Friday, this is not the place to broadcast your invention, your idea, or promote your product. A lot of that is potentially confidential. You want to reserve that for a legal consultation with either myself or someone from my team. So please hold off on any confidential disclosures. We don't want to have that. But obviously, you're welcome to ask questions about the process in general, even hypotheticals, that may or may not be on point with what your invention is about. So I welcome all those as well. Okay, as a lot of you guys know, repeat, watchers, listeners, this is one of the one ways that I get out to the community and share my knowledge. But no, this is not the only. Okay, so if you have a private question you want to follow up with me on, I do welcome your question via email. And so you're welcome, as always, to send me an email to jd@boldip.com. I'll get back to you usually within one business day. I'm pretty good about that. So you've got email, you've got the book download link. I'm going to jump off to the avo.com questions that I answer for our audiences around the country. And for anyone that has live questions, you're welcome to fire those away. I'm here, and so there's about a 1 or 2 minute lag. If you're asking a question and you're on YouTube, especially, it's about a 1 or 2 minute lag. So I'm not ignoring you. It just hasn't come to me yet. When I see your question pop up, I will take a break from the Avo questions and get to you right away. All right, everybody, let's get to it. Okay, so on avo.com, I've got a subscription to answer questions from around the country, anonymous questions that come in through the week. And it looks like I've got 4 questions teed up for today. The first one is on patent applications, and coming out of Victorville, California. How do I speak with a patent lawyer? I need to speak with a patent lawyer about my innovative idea as soon as possible. Thank you. Okay, that's it. So it's a pretty simple question. You can do a lot of different things, right? Some people, a lot of folks that we work with really enjoy the fact that we are a virtual law firm. And I think a lot of law firms and companies, for that matter, given COVID and the recent issues with being in person and contracting the diseases, they want to stay virtual and do video conferencing and phone meetings, and that's fortunately that's one way we have done business for 5 or 6 years. We've been really in tune with reaching out to contacts, maintaining that relationship with clients via video and email and phone. So a lot of firms like ours are pretty well positioned, and I think that's the best way, I think, to begin a conversation with how to speak with a patent lawyer, or any lawyer, any profession that you're looking to try to introduce. Start out with a phone call, maybe a video call, get a sense as to whether they're a good fit for you and they're going to be able to solve your problem. You should treat it like an interview, okay? Both ways should be treated like an interview. I do this with a lot of my prospective clients, as I tell them, this isn't necessarily me trying to convince you, Mr. and Mrs. Client, that we're a good fit for you, but you're actually trying to convince me that I should take you on as a client. We are, and a lot of professions out there should be more choosy, right? We need to make sure that our firm really can suit your needs best. If we're not the best, then I want to refer you out to someone I think could. That's sort of a duty I think all professions and certainly attorneys owe to their respective clients. So if the attorney is coming out too salesy, a little too pushy, that's a red flag, right? They're trying to do too much. They're outside their means. They're not comfortable, or they're perhaps too hungry and financially burdened. So you don't necessarily want to start a relationship out with someone like that. Okay, well, if that helped answer your question, let me jump back to the live feed, see if we have anybody with questions that have come in. Nothing yet, but thanks for the thumbs up and the like. Always love those likes, and that's one way we get out to a bigger audience. I really would like this Facebook Live to be, of course, a bigger audience, and that's the only way we can do this is through you and your help. Sharing the link, giving us a thumbs up, providing us that visibility on the social platforms that we're on. And a quick little plug to StreamYard. We're using this new platform, which is awesome. We're able to simultaneously cast to YouTube, Facebook, and Periscope via Twitter. So we're live on all 3 platforms right now. So if we're coming in live, we want to be able to share that and share the answers, and the fact that I'm here ready to answer any questions that you've got. If you enjoy that, you like that idea, and share it with someone you may know of, either on a personal direct message or via your social friends channel. It would mean a lot to me if you could do that. All right, let's jump back to our questions. This one is going to be trademark related. Okay, so I've answered a lot of questions in the patents over the last few weeks, and there has not been any questions that have come up in the past 7 days on patents. So there are three questions on trademark applications that I can do my best at. This one is out of Brooklyn, New York. I have a business name that I would like to use and eventually trademark. I did searches on the USPTO to the best of my ability, and it appears that I can use the name. How do I know that I can? Well, that is one of the best questions to ask, right? A lot of business owners will jump the gun, file their own registration, kind of get somewhere in the middle and stuck, talking with the trademark USPTO attorney, and they're rejecting their application. And by then, a lot of the damage has already been done. The application wasn't structured correctly, and we have to basically start over. But you're asking a great question, in that the issue is legal, and that, hey, just because someone isn't using the name you want exactly, if someone's using a similar name or even a sound-alike name in the same industry and classification that you're going for, that could be an issue. And so you want to be able to spot that before you apply. And so the best way to handle that is to hire a trademark attorney, an IP firm that can do a trademark registrability search. Much like a patent search, we're going to make sure there's a clearance, so there's no other entity or individual that has rights over that mark for the goods and services you're hoping to go to market with. That last part is important, of course, what your plans are. So having a good business plan, not just what you're hoping to sell next year, but what you might sell 5 to 10 years down the line, it's really important, because you want to try to get rights on what products and services you can demonstrate and hopefully carve a market niche out of. So do get with an attorney. Obviously, we're a good one option at Bold, but you've got other trademark attorneys that are well competent to help you get to that answer. Hope it answered your question there. All right, so question number 2 on trademarks out of Atlanta, Georgia. Can I partially trademark my business name? They said, I registered my business name with the state of Georgia, and this is likely with the Secretary of State. I want to know if my company's name is something that I should register, Okay, and so they actually did volunteer the name of the company. It's called Dawn Park Cleaning Incorporated. Okay, that's the name of the company. They want to try to trademark Dawn Park. Okay, well, I would say just initially, a lot of entrepreneurs, get this idea that if I have a business name, I need to register the trademark for exactly what the business name is. Not always the case. It's actually about how you're going to be presenting your products or services to your clients, to your customers. It's all about what the customers perceive. So if on your marketing, if on your storefront, if you've got one, right, your website, will you say Dawn Park Cleaning, or will you just say Dawn Park? And so if you're going for that, that approach should help. But oftentimes you'll see that there's Procter and Gamble, but the product they're looking to register is Tide, right? TIDE. That's the actual registered trademark is Tide, not the company name. In many cases, it makes sense to get registrations for both, but just want to make sure that that there's a separation there. Looks like in your case, your question is about whether or not to include the word cleaning. And your intuitions are correct, and that if you include the word cleaning, if that's what your company is doing, is cleaning for homes, that's merely descriptive. Okay, that's just describing what this service is, and you'll likely not be able to get immediate registration for words that describe what you're doing, what your product is, because it is not distinctive. Now, Dawn Park, certainly could be distinctive. That to me doesn't resonate as something related to cleaning services. And so long as there's not another service offering entity using Dawn Park, it's likely you'll be able to register that. Okay, but it's completely different from the state registration, which is a state trademark. The federal trademark register will look across the country at anyone using that name, and of course anyone that's registered that name or similar names for your industry and classification, which is on cleaning services. Hope answers your question there. Okay, no live questions, so we're kind of a quiet Friday, but it's good to have people on. Last question today, trademark app is out of Florence, South Carolina. Their question is about starting up a candle business, which is kind of fun. The name I want is being used by multiple people on social media. Is it not trademarked nationally, only statewide? Can I use this name and trademark it nationally? Great question. So, it's going to be, depending on how they're using their mark, and if they have begun serving their community, whoever their customers are, at a national or international level. If they're selling products under that name, internationally or multi-state, that could be a bad thing, right? In terms of common law, they're actually already starting to earn that trademark rights over wherever they have customers. So Snazzy Jeans, right? Snazzy is online. They haven't got a federal registration, but they've just been selling under the name Snazzy Jeans, and they're selling on their Facebook or social media platforms or Etsy, whatever it is. And they're selling to multiple parties. Maybe they've sold to 30 different states. Under common law, they do have rights to claim priority back to when they first started using that name, which could be 2019 or 2018, for those regions that they had their customers in. It would be a pretty difficult challenge for you to try to go for the same mark, Jazzy Jeans, Jazzy Apparel. There is an argument to be said that where they did not have customers in those other 20 states, in my example, you would be able to get some protection federally, but those 30 states, the other national dominance, could be at issue. And I think a trademark examiner would probably reject your application just because a majority of the states, the majority of the country already knows where Snazzy Apparel comes from, and it's not your company. So it would be kind of a tricky deal. It does, of course, depend case by case. So get with us, shoot me an email, we can get started helping you with that. All right, guys, it's pretty quiet out there. Really happy to have the viewers on that we do. As always, it's a pleasure to be with you. This was a quick 15 minutes. If you do have any questions, I will stay on for one more minute just to make sure as we wrap up. But I'll see you guys next time on the Bold Today show. And I'm here every Friday. Hopefully, gonna bring on a guest with another inventor that we've just got a patent issued for. So I like bringing those folks on. Last week we had Phil Martino of ZipJewel, and it was a real pleasure to have him on. So again, I'll just stay here for another minute just to make sure there's no questions. All right. Well, we're at that 1 minute mark. Thank you guys. Oh, here we go. We got a question. I'm glad I waited. Tony, if you apply something to a product from a safety standpoint, would this be considered a utility patent? Apply something to a product from a safety standpoint. Yeah. Okay. So what you're talking about is an improvement. Okay. So there's a product that already exists, it sounds like, and you're improving on it, making it more safe. If that adaptation, that modification is novel, non-obvious, and has utility, it's patentable, right? The potentially follow-on question you might be asking is, hey, can I sell this product with the improvement on my own? And well, the answer is likely not. If there's an enforceable patent that covers that base product without your improvement, you'll need to seek a license from them to begin selling that without infringing their base. But what a lot of inventors do, and I think probably the majority of patents that are issued today are improvements. They will try to license that improvement, that safety measure, to the company that's selling that base product. And it will allow them to obviously maybe capture more market share, offer that new safety product or gadget at a new price point, right? So hopefully that helps you move forward there. And congrats on coming up with something to make things more safe. And making the world better, that's what we're all about. So thanks, Tony, for your question. I'll hang it for just 1 minute and see if there was a follow-up from Tony or anybody else out there. You're welcome. So for anyone that might have missed it, my name is J.D. Houvener, and I'm a patent attorney, owner here at Bold Patents Law Firm. And I do this every week, every Friday, 9 a.m. Pacific and noon on the East Coast, to catch you guys during lunch to try to just answer questions. I'm a, open book. I'm a huge advocate of volunteering information, getting inventors educated. The horror stories I hate to hear are those inventors that got taken advantage of by, InventHelp, the invention home, invention promotion companies get caught up in sort of just companies that aren't attorneys, aren't giving legal advice first. All inventors are really, in my opinion, it's the lifeblood. It's why our forefathers put inventions in Article 1 of our Constitution. And that's why the patent laws have been such a foundational part of how we've been #1 in the world for so many years, and why it's important now that we remain that way. So just 1 more minute here to see if any other questions come in. Otherwise, we'll wrap up and hopefully see more of you next week as we introduce one of our new inventors. We've got a whole handful. A lot of new inventors have just got their patents issued, and I'd love to have them on to help tell their story. Obviously just getting the patent, it's not, as we heard from Phil Martino last week, it's not the end of the day. You're not going to have people coming to you just because you got a patent. You've got to develop a business plan, and you got to have a plan in place to go make money to monetize, which involves a whole lot of other things. I know that we are here to help you. We've got good resources to do that. All right, guys. Well, thank you again for tuning in. I'll chat with you next week. Have a great day, everybody. Go big, go bold.